I looked out my window and watched the HOA crew tearing up my property line at 7 in the morning, their machinery grinding into frozen earth like they owned the place. They didn't. I did. Every square inch they were working on belonged to me, and I had the survey documents to prove it. My name is Derek Atwood, and I had lived in Aspen Ridge, Colorado for 3 years. The neighborhood sat in a wealthy pocket outside of Denver where people had more money than sense, and even more opinions about how everyone else should live. I had bought my property specifically because it sat at the edge of the development, with a generous lot that extended well beyond what most people assumed. The previous owner had been smart, buying extra land when the neighborhood was first developed, and I had inherited that foresight when I purchased the house. The HOA, led by a woman named Patricia Morrison, had been a thorn in my side since day one. She was everything you would expect from someone who made being on the HOA board their entire personality. Mid-50s, blonde highlights that were too perfect, designer athleisure where that cost more than most people's monthly mortgage, and a smile that never reached her eyes. She drove a white Mercedes SUV and had a voice that could cut through steel when she wanted it to. I grabbed my coffee and threw on a jacket, heading outside into the bitter February morning. The temperature hovered around 15 degrees, and my breath came out in white clouds. 3 workers in heavy coats were operating equipment while Patricia stood nearby with another board member, clipboard in hand, pointing at various spots on the ground. "Morning," I called out, walking across my frost-covered lawn toward them. "Mind telling me what you are doing on my property?" Patricia turned, and that fake smile spread across her face. "Good morning, Derek. We are installing heated walkways for the community. The board voted on it last month. Did you not receive the notice?" "I received a notice about heated walkways being installed on common areas," I said, keeping my voice level. "This is not a common area. This is my land." She laughed, actually laughed like I had told a joke. "Oh, Derek. I know you are new here, but this section has always been part of the common space. It connects the community paths and provides access between the neighborhoods. We checked all the records." "Then you checked them wrong," I replied. "I had a survey done when I bought this place. This land, everything from my back fence line extending 30 feet toward the main path, belongs to me. You are trespassing." The smile finally faded. "That cannot be right. We have had access to this area for years." "Access that the previous owner apparently allowed," I said. "But allowing access does not mean transferring ownership. I own this land, and you are currently tearing it up without my permission." One of the workers had stopped operating his equipment and was watching us now. Patricia's face had gone red, though whether from cold or anger I could not tell. "We will see about this," she said tightly. "The HOA has rights to certain areas for community improvement." "Not on private property you don't," I said. "But you know what? Do not stop on my account. Keep working." That confused her. Her eyes narrowed. "What? Keep working," I repeated. "Finish your heated walkways. Do the whole installation. I would hate to interrupt community improvements." Patricia stared at me like I had grown a second head, but I just smiled, took a sip of my coffee, and walked back inside. Through my window, I watched her have a heated discussion with the other board member, a man named Richard something who always wore polo shirts even in winter. They kept gesturing toward my house, then back at the worksite. Eventually, Patricia made a phone call that lasted about 10 minutes, full of animated hand movements and facial expressions. When she hung up, she marched over to the workers and told them to continue. I watched them work for another hour before heading to my home office. I had taken the day off from my job as a software consultant specifically because I knew this confrontation was coming. I had received the HOA notice about heated walkways 3 weeks ago, and I had immediately pulled out my property survey and cross-referenced it with the planned construction path. They overlapped by almost 40 feet in one section, all on my land. I had considered stopping them immediately. I had even drafted an email to Patricia and the board. But then I had done some research, consulted with a real estate attorney friend in Boulder, and realized that letting them complete the work might actually be the better play. Colorado had specific laws about property improvements made by unauthorized parties, and they heavily favored landowners who could prove clear ownership. Over the next 2 weeks, I watched the HOA pour money into my land. They excavated, laid down insulation and heating cables, poured new concrete, and installed beautiful heated pavers that would keep the walkway clear of snow and ice all winter. The system they were installing was top of the line, the kind that ran about $200 per square foot when you factored in materials, labor, and electrical work. They were putting down roughly 800 square feet of heated walkway on my property. I did the math. That was approximately $160,000 worth of improvements on land I owned, land they had no right to build on. Every few days, Patricia would stop by with different board members, always with that fake smile, always with some comment about how nice the community improvements were going to be. I always agreed. I always told them it looked great. I never once mentioned that they were building on my property or that I had any issue with it. "You seem surprisingly supportive of this project," Patricia said one afternoon, catching me as I checked my mail. "I have to admit, I expected more resistance from you." "Why would I resist community improvements?" I asked innocently. "Well, you were so insistent about the property line issue," she said, her tone probing. "Oh, I am still certain about my property line," I said. "But you seemed confident about yours, so I figured we would let the professionals sort it out eventually. No point in stopping progress over paperwork, right?" She looked uncertain but nodded. "Right. Well, I am glad you are being reasonable about this." The work finished on a Thursday in early March. The heated walkways looked incredible, I had to admit. They had done excellent work, with subtle lighting along the edges and a smooth, even surface that would be perfect for walking even in the worst weather. The system was fully functional, already melting the light snow that had fallen the night before. Patricia organized a little ribbon-cutting ceremony for the following Saturday. She invited the whole neighborhood, set up a small table with coffee and pastries, and gave a speech about community investment and property values. I attended, standing in the back, sipping terrible coffee from a paper cup. "These heated walkways represent what makes Aspen Ridge special," Patricia announced to the gathered crowd of about 30 people. "We invest in our community. We make improvements that benefit everyone, and we do it together as neighbors." Everyone applauded. I applauded too. Monday morning, I had my attorney, a sharp woman named Jennifer Campbell from Boulder, send a certified letter to the HOA board. The letter included my property survey, documentation from the county assessor's office, historical property records, and a detailed invoice for the use of my land. The invoice was itemized. 800 square feet of heated walkway installation at market rate for finished improvements, $160,000. Use of land during construction, $5,000. Damage to existing landscaping, $3,000. Total, $168,000. Payment due within 30 days. Jennifer had advised me on the pricing. We could have gone higher, could have charged them for permanent use of the land or forced them to remove everything. But the goal was not to be unreasonable. The goal was to make a point and get compensated fairly for what they had done, My phone started ringing around 10 in the morning. Patricia. I let it go to voicemail. She called 4 more times. I ignored all of them. Then Richard called. Then another board member named Susan. I ignored those too. The first voicemail from Patricia was polite confusion. Derek, this is Patricia Morrison from the HOA board. I received a very strange letter from an attorney today. Please call me back so we can discuss this misunderstanding. The second voicemail was less polite. Derek, I do not know what game you think you are playing, but this invoice is ridiculous. Call me back immediately. The third was angry. You let us build those walkways knowing you were going to pull this stunt. That is fraud, Derek. You are going to regret this. I did not call back. Instead, I forwarded all the voicemails to Jennifer. The HOA emergency meeting was called for that Wednesday evening. I received a formal notice requiring my attendance. Jennifer advised me to go, so I went. The meeting was held in the community center, a nice building with a stone fireplace and large windows overlooking a small pond. About 50 people showed up, which was unusual. Normally, these meetings drew maybe 15 people, mostly board members and busybodies. Word had spread about the heated walkway dispute. I sat in the back row. Patricia stood at the front with the other 4 board members, and she looked like she had not slept well. Her makeup was slightly off, and her smile was completely gone. We are here to address a legal dispute between the HOA and Derek Atwood, she began, her voice clipped and professional. Mr. Atwood has made claims about property ownership that conflict with our records and our community improvement project. My claims are backed by county records, I said from the back row. I am happy to provide copies to anyone who wants them. You let us complete the entire project, Patricia shot back, dropping the professional tone. You watched us work for weeks and said nothing. You even encouraged us to continue. That is deceptive. I mentioned the property line on the first day, I said calmly. You told me you had checked your records and that you were confident. I decided to let you proceed rather than force a confrontation. I figured adults could sort out paperwork after the fact. Paperwork that includes a bill for $168,000, Richard added, reading from the letter. That is extortion. That is fair market value for the improvements you installed on my property without permission, I corrected. You are welcome to have the work appraised independently. I think you will find my numbers are accurate. A man I did not recognize raised his hand. Can someone explain how this happened? How did the HOA not know they were building on private property? Patricia's jaw tightened. We reviewed our maps and records. This area has been used as community space for years. We had every reason to believe it was part of the common areas. Except for the county records that clearly show otherwise, I said, which are public information, which a simple property survey would have revealed. Did the HOA get a survey done before starting construction? Someone else asked. The silence from the board answered that question. This is a waste of time, Patricia said. We are not paying this fraudulent invoice. The HOA will be consulting with our attorney and pursuing all available legal options against Mr. Atwood for his deceptive behavior. Looking forward to it, I said pleasantly. The meeting devolved into chaos after that, with people arguing about property rights, HOA authority, and whether I had acted ethically by letting them finish the work. I left after about an hour, having said everything I needed to say. Jennifer called me the next morning. The HOA attorney contacted me. His name is Marcus Webb, works for a firm in Denver. He is claiming you had a duty to stop the construction, and that allowing it to continue constitutes fraud or unjust enrichment on your part. What did you tell him? I told him that you notified them on the first day of construction, that it was your property. which multiple witnesses can confirm. I told him that you had no legal obligation to stop them from trespassing, and that their failure to perform due diligence before starting construction is not your problem. I also told him that if they prefer, you would be happy to have them remove all the improvements and restore your land to its original condition at their expense. I laughed. I bet he loved that. He did not. He's going to talk to his clients and get back to me. 2 weeks passed with no response. The heated walkways continued to function perfectly, melting every bit of snow that fell on them. I used them regularly, enjoying the warm pavement under my feet during my morning walks. Several neighbors commented on how nice they were. I always agreed. Then I received a formal response from the HOA attorney. They were offering to pay me $15,000 for an easement that would allow the walkways to remain on my property in perpetuity. I laughed so hard I almost dropped my coffee. Jennifer was more measured in her response. It is an insulting offer, but it is a starting point. They are acknowledging that it is your property, which is significant. They want to pay me $15,000 for something that cost them over $160,000 to install. They are hoping you will take a small payout to avoid a legal fight, she explained. It is a common negotiation tactic. Counter with the full amount, I said. No discount, she did. The HOA attorney responded that his clients felt the full invoice was punitive and unreasonable, and that they would rather litigate than pay it. Then we litigate, I told Jennifer. You are sure? This could get expensive even if we win. I am sure. They trespassed on my property and made massive improvements without permission after I explicitly told them it was my land. They do not get to profit from their own negligence. The lawsuit was filed in county court in late March. The HOA filed a countersuit claiming fraud, unjust enrichment, and requesting that the court force me to allow the walkways to remain for nominal compensation. The case moved slowly, as these things do. Discovery took months. Both sides exchanged documents, property records, communications, and witness lists. The HOA tried to prove that the land had historically been treated as common area, digging up old photos and testimony from longtime residents. My team focused on the legal documentation, the clear property lines, and the fact that I had warned them on day one. During this time, Patricia's behavior escalated. She started filing complaints against me for every minor possible violation she could imagine. My grass was too long by half an inch. My trash cans were visible from the street for 30 minutes longer than allowed. My car was parked 6 inches over my driveway edge onto the common area. Each complaint came with a fine: $50 for the grass, $100 for the trash cans, $75 for the parking violation. I documented everything and sent it all to Jennifer. They are retaliating, she said. This actually helps our case. Keep records of everything. I did. I took photos, saved every email and letter, and recorded dates and times. When Patricia started showing up at my house to personally inspect my property for violations, I installed security cameras. The footage of her measuring my grass with a ruler became a highlight of my week. The breaking point came in June. I came home from a meeting in Denver to find a bright orange sticker on my front door declaring my house in violation of community standards. The violation: my front door color was not approved. My front door was forest green. It had been forest green when I bought the house 3 years ago. It had been forest green for at least a decade before that, according to the previous owner. Patricia claimed it needed to be reapproved under new community standards guidelines. The fine was $500, with an additional $100 per day until the violation was corrected. I called Jennifer immediately. This is harassment, Agreed. I will file a motion first thing tomorrow. She did more than that. She filed a motion for a restraining order against Patricia specifically, citing harassment and retaliation. She also filed a motion to expedite the main case, arguing that the HOA's behavior demonstrated bad faith and made continuing the dispute untenable. The hearing for the restraining order was scheduled for the following week. I showed up with Jennifer and 3 accordion folders full of documentation. Patricia showed up with Marcus Webb and an attitude. The judge was a no-nonsense woman in her 60s named Judge Sarah Brennan. She listened to Jennifer present our case, reviewed the timeline of complaints and fines, and watched some of the security footage of Patricia on my property. Then she turned to Patricia. "Mrs. Morrison, did you personally inspect Mr. Atwood's property looking for violations?" "I did," Patricia said proudly. "As HOA president, it is my responsibility to ensure all residents comply with community standards. How often did you inspect his property compared to other properties in the neighborhood?" Patricia hesitated. "I do not have exact numbers." "Mr. Atwood's attorney has provided data showing you inspected his property 47 times in 3 months, while other properties were inspected an average of twice per year. Can you explain this discrepancy? Mr. Atwood has been non-compliant and difficult. He required additional oversight. Mr. Atwood has been engaged in a legal dispute with the HOA, a dispute in which he appears to have a strong case based on property records. Your increased scrutiny began immediately after that dispute started. That looks like retaliation, Mrs. Morrison." Patricia's face went red. "I am simply doing my job. Your job is not to harass residents who disagree with the HOA," Judge Brennan said sharply. "I am granting a temporary restraining order. Mrs. Morrison, you are to have no direct contact with Mr. Atwood and are not to conduct inspections of his property unless you are conducting simultaneous inspections of at least 5 other randomly selected properties in the neighborhood. Any violations of this order will result in contempt charges." "Am I clear?" "Yes, Your Honor," Patricia said, her voice barely controlled. The judge also granted the motion to expedite the main case. The trial was scheduled for August. As we left the courthouse, Jennifer looked satisfied. "That went well. She is going to be furious," I said. "Let her be furious from a distance." The restraining order made neighborhood life interesting. Patricia clearly wanted to confront me every time she saw me, but could not do so legally. She would see me at the mailbox or walking the heated paths and would visibly tense, her face reddening, but she would turn and walk away. Other board members started approaching me instead, trying to convince me to settle. "This is tearing the community apart," Susan told me one evening. She had caught me coming home from work. "People are choosing sides. Friends are not talking to each other. Is it really worth all this?" "I am not the one who built on someone else's property without checking," I said. "I am not the one who refused to acknowledge a mistake and make it right. The HOA did this, not me. Patricia says you set us up, that you let us build knowing you would charge us." I told Patricia it was my property on the first day. Multiple people heard me. She chose not to believe me, Susan sighed. "Just think about the community, okay? We are all neighbors." I did think about the community. I thought about how an organization that was supposed to protect property values and maintain standards had become a vehicle for one person's power trip. I thought about how they had wasted over $160,000 of community funds on a project they had not properly vetted. I thought about how they were now spending even more money on legal fees rather than admitting they had made a mistake. The trial lasted 3 days in mid-August. Both sides presented their evidence. The HOA argued that the land had been treated as common area for years, that community members had used it freely, and that I had acted in bad faith by allowing the construction to continue. My side presented the property survey, county records, and testimony from the surveyor who had done my initial assessment. We also presented Patricia's own words from that first morning, where multiple witnesses confirmed I had told her it was my property, and she had dismissed my concern. The key moment came when Jennifer Cross examined Patricia. "Mrs. Morrison, when Mr. Atwood told you on the first day of construction that the land was his property, what did you do?" "I told him we had checked our records," Patricia said stiffly. "What records did you check?" "Our HOA maps and documents." "Did you consult county property records?" "We reviewed what we had." "That is not what I asked. Did you consult official county property records?" Silence. "Mrs. Morrison, no," Patricia admitted, "but we had used that land for years without issue." "Using land without objection does not make it yours, does it?" "No, but did you have the property surveyed before beginning construction?" "No." "Did you consult with a real estate attorney about property boundaries before starting a $160,000 construction project?" "No." "Did you, at any point before or during construction, take any steps to legally verify that the HOA actually owned the land you were building on?" Patricia's jaw clenched. "We trusted our existing records, records that turned out to be wrong." "Yes." Jennifer let that sit for a moment before continuing. "After Mr. Atwood told you it was his property, you made a phone call. Who did you call?" "Our attorney." "And what did he tell you?" "Objection," Marcus Webb said quickly. "Attorney-client privilege." "Sustained," Judge Brennan said. But the damage was done. The implication was clear. Patricia had called her attorney, and even after that call, she had chosen to continue construction. That suggested she had either received bad advice or ignored good advice, neither of which helped the HOA's case. The defense also tried to argue that I had a duty to stop the construction, that my silence constituted consent or fraud. Jennifer demolished that argument by pointing out that I had explicitly stated it was my property, had no legal obligation to physically prevent trespassing, and had never given written or verbal consent for the work. "Mr. Atwood told them they were on his land," Jennifer argued in her closing. "They chose not to believe him. They chose not to verify. They chose to proceed with an expensive construction project without doing basic due diligence. Now they want the court to bail them out of their own negligence. That is not how property rights work. You do not get to build on someone's land and then claim they should have stopped you harder." Judge Brennan took 2 weeks to issue her ruling. I received the call from Jennifer on a Tuesday afternoon in early September. "We won," she said. "Complete victory. The judge ruled that you own the property, that the HOA had no right to build on it, and that their failure to verify property boundaries was negligent. She awarded you the full invoice amount plus legal fees and court costs." I sat down hard in my desk chair. "The full amount." $168,000 in damages, plus roughly $75,000 in legal fees and costs. Total of $243,000. She also ruled that the HOA must either pay fair market rent to keep the walkways in place or remove them at their expense. How much is fair market rent for an easement on that much land in this neighborhood? The judge set it at $3,000 per year, adjusted for inflation. The HOA has 60 days to decide whether to pay, remove the improvements, or negotiate an alternative arrangement with you. I actually laughed. Patricia is going to lose her mind. "There is one more thing," Jennifer said. The judge included language in her order criticizing the HOA's conduct during the dispute. She specifically mentioned the retaliatory fines and inspections. She stopped short of sanctions, but her order basically invites you to file a separate harassment claim if you want. Do I want to? That is up to you. You have already won the main battle. I thought about it. Let me see how they respond to this first. The HOA's response came in the form of an emergency special meeting announced for the following week. The agenda was simple: discuss the court ruling and vote on the board's future actions. I attended. So did most of the neighborhood. The community center was packed, with people standing along the walls. Patricia looked defeated as she called the meeting to order. Her usual confidence was gone, replaced by a brittle defensiveness. As you all know, the court ruled against the HOA in the property dispute with Derek Atwood, she began. The judge ordered us to pay $243,000 and make a decision about the heated walkways within 60 days. The room erupted in shocked murmurs. Several people had not known the full amount. How did this happen? Someone called out. We made decisions based on the information we had, Patricia said. We believed the land was community property. Did you check? Another voice asked. We consulted our records. But did you check with the county? Did you get a survey? Patricia's silence answered the question. Richard stood up. I move that we accept responsibility for this mistake and work with Mr. Atwood to reach a reasonable settlement. Second, Susan said immediately. I disagree, Patricia said. We should appeal the decision. The judge did not fully consider our historical use of the land. We already lost on that argument, Richard said, and we cannot afford to keep fighting this. We have already spent nearly $80,000 on legal fees. The special assessment to cover this is going to be bad enough without adding more legal costs. That caused another eruption. Special assessment meant every homeowner in the development would have to pay extra HOA fees to cover the judgment. How much are we talking? Someone asked. Richard consulted his notes. Roughly $4,000 per household, spread over the next year. The room went ballistic. People started shouting, demanding answers, asking how the board could have been so careless. Patricia tried to maintain control, but it was useless. Someone called for a vote of no confidence in the entire board. Someone else demanded Patricia's immediate resignation. I sat quietly in the back, watching it all unfold. I felt no satisfaction exactly, but no guilt either. This was the consequence of their choices. Eventually, Richard managed to restore some order. We need to vote on our response. I have a motion on the floor to accept the judgment and negotiate with Mr. Atwood. All in favor. 4 hands went up. Patricia sat with her arms crossed, refusing to vote. Motion passes, Richard said. Patricia, as board president, you are authorized to reach out to Mr. Atwood's attorney and begin negotiations. I will not, Patricia said flatly. I do not agree with this decision. If the board wants to negotiate, someone else can do it. Then I move that we elect a new board president, Susan said. Someone who will actually act in the community's best interest. That vote passed too, with only Patricia voting against. Richard became the new president. Patricia stood up, gathered her papers, and walked out without another word. Richard approached me after the meeting. Derek, I am sorry. This whole thing was mishandled from the beginning. Can we talk? We met at a coffee shop in Denver the next day, neutral territory. Richard brought Susan and another board member named Tom. I brought Jennifer. We want to make this right, Richard said. The full judgment would require a special assessment that would be crushing for a lot of families in the neighborhood. Is there any flexibility? What are you proposing? Jennifer asked. We pay you $100,000 as a lump sum. You keep the walkways as they are, and you waive the remaining damages and ongoing rent. I considered it. $100,000 was a substantial amount, and it would spare the neighborhood some pain. But it was also less than half what I was owed. $150,000, I said. Plus the HOA formally acknowledges in writing that they built on my property without permission, and they issue a written apology for the retaliatory harassment during the dispute. Richard winced but nodded. I think we can do that. Let me bring it to the full board. The vote passed 4-1, with Patricia being the only dissenting vote. The HOA paid me $150,000 in 2 installments, issued a formal letter acknowledging their error, and published an apology in the neighborhood newsletter. The letter was professional but clear. The board had failed to properly verify property boundaries and had made the situation worse by retaliating against me for asserting my legal rights. Patricia resigned from the board entirely a week later. She tried to make it sound principled, claiming the board had abandoned its responsibility to fight for community interests. But everyone knew the truth. She had gambled with community funds, lost badly, and could not handle the consequences. The special assessment still happened, but at a reduced rate of about $2,000 per household. People were not happy about it, but they directed their anger at the previous board's incompetence rather than at me. Several neighbors actually apologized to me for the whole situation. We should have questioned Patricia more when you first raised the issue, one neighbor told me. She has always been so confident that we just assumed she knew what she was doing. The heated walkways remained, and they were beautiful. They functioned perfectly through the next winter, keeping the paths clear and safe. I used them almost daily, and I never paid a cent for their installation or operation. The HOA covered all maintenance and electricity costs. I ran into Patricia once more, months later at a grocery store in Denver. She saw me from across the produce section. For a moment, I thought she might actually approach me, might say something. But instead, she turned her cart around and walked the other way. I did not chase her. There was nothing left to say. The whole experience taught me something about HOAs and the people who run them. They operate with a lot of assumed authority but very little actual accountability. They collect fees, make rules, and enforce standards, often without anyone questioning whether they are acting legally or appropriately. Most homeowners just go along with it because fighting is exhausting and expensive. But when you are in the right, when you have the facts on your side, it is worth standing your ground. Not out of spite or revenge, but because property rights matter. Because organizations need to be held accountable for their decisions. Because sometimes the only way to stop an overreach is to make it too expensive to continue. The new board, led by Richard, turned out to be much more reasonable. They still enforced community standards, but they did so fairly and consistently. They stopped the petty harassment. They started actually checking facts before making major decisions. The neighborhood improved as a result. As for the money, I invested most of it. Some went to Jennifer for her excellent work. Some went to a nice vacation to Hawaii I had been putting off. And some went to charity, specifically to a legal aid fund that helps homeowners fight unfair HOA actions. I figured if my situation could help others stand up for their rights, the whole mess would have been worth it. The heated walkways still run every winter. Every time I walk on them, feeling the warmth through my shoes as snow melts around me, I remember that morning when I watched the HOA tear up my property. I remember the choice I made to let them finish, to document everything, to stand my ground. I still think it was the right choice. The property values in Aspen Ridge stayed strong, despite the special assessment drama. The heated walkways actually became a selling point for the neighborhood, something realtors mentioned when showing homes. It was ironic that Patricia's expensive mistake ended up being good for the community in the long run, just not in the way she had intended. I occasionally saw other former board members around the neighborhood. Most nodded politely or exchanged brief pleasantries. Susan actually became a friend of sorts. She stopped by one spring afternoon while I was working in my yard. "I owe you an apology," she said. "I went along with Patricia on a lot of things I should have questioned. The Walkway project, the retaliation, all of it. I was too worried about making waves." "You voted to do the right thing in the end," I said. "That counts for something. Still, I let it get that far in the first place." She paused, watching me plant some new shrubs along my fence line. "For what it is worth, the new board is implementing some changes. We are requiring professional surveys for any construction projects. We are limiting fines and inspections to prevent harassment. We are trying to learn from this." "That is good to hear." "Patricia is telling people she was forced out by a witch hunt," Susan added. "That the neighborhood turned on her unfairly." "People believe what they want to believe," I said. "Most people know the truth. She cost everyone thousands of dollars because she was too proud to admit a mistake." Susan helped me place one of the shrubs. "Can I ask you something? When you told us to keep building that first day, did you already plan to bill us?" "I plan to protect my property rights," I said. "I figured it would be easier to resolve everything after the fact rather than get into a fight while heavy machinery was running. I also figured if you were going to build something expensive on my land without permission, you could either pay for the land or remove what you built. That seemed fair." She nodded slowly. "It was fair, we just did not like it." After she left, I thought about that conversation. Fair and liked are not the same thing. Fair means everyone plays by the same rules. Liked means everyone gets what they want. The HOA had wanted to use my land without my permission. That was never going to be fair, no matter how much they liked it. Years passed. The heated walkways continued to function. The HOA under Richard's leadership became known as one of the more reasonable ones in the area, actually working with homeowners rather than against them. Property values rose. Life went on. I heard through the neighborhood grapevine that Patricia had moved to Arizona. Apparently, she joined an HOA board there too. I felt sorry for her new neighbors but figured they would learn to handle her eventually, just like we had. My property, with its extra land that extended into what everyone assumed was common area, became a reminder to the whole community. A reminder to check facts before making assumptions. A reminder that power needs to be exercised with care. A reminder that sometimes the quiet guy in the back of the room actually knows what he is talking about. I expanded my garden that spring, planting trees and flowers along the property line that the HOA had tried to claim. I made sure to stay within my boundaries, of course. I had the survey stakes to prove exactly where those boundaries were, and I was not about to give anyone ammunition for future disputes. One morning in late May, I was watering my new plants when Richard walked by with his dog. "Yard looks great," he called out. "Thanks. Finally getting it how I want it." He paused, letting his golden retriever sniff around my mailbox. "You know, we saved some money this year by not having any legal disputes. Novel concept." I laughed. "Who would have thought?" The board voted to put the savings into the reserve fund. "You know, for emergencies, and maybe for properly surveying our actual common areas just so we know what we actually own." "Sounds responsible." "We are trying." He hesitated. "I know the special assessment was hard on people. I know some folks probably still blame you for it, but you were right. We screwed up and we needed to be held accountable." "I appreciate you saying that." "Yeah, well, learn from your mistakes and all that." He tugged his dog's leash gently. "Have a good day, Derek." "You too, Richard." As I watched him walk away, I thought about how the whole situation had changed the neighborhood dynamics. Before the walkway dispute, the HOA had operated with unquestioned authority. Patricia had ruled with an iron fist, and most people had just accepted it because challenging the HOA seemed too difficult. Now, people asked questions. They wanted to see documentation. They insisted on proper procedures. The board meetings actually included real discussions rather than rubber stamping whatever Patricia wanted. It was not perfect, but it was better. My home office looked out over the section of heated walkway that sat on my property. I spent a lot of time in that office, working on various consulting projects, and I would often glance out the window at those paths. They represented different things to different people. To the neighborhood, they were a nice amenity that came at too high a price. To the HOA, they were a lesson in due diligence. To Patricia, wherever she was now, they were probably a bitter reminder of defeat. To me, they were proof that standing up for yourself works. That documentation and facts matter more than confidence and bluster. That patience can be a powerful strategy. The legal side of everything had wrapped up completely. All payments made, all documents signed, all appeals deadlines passed. The case was fully resolved, and I owned both my property and the improvements on it, free and clear. Jennifer called me one last time about 6 months after the settlement was finalized. Got a question for you. I have a client in a similar situation. HOA built a retention pond that extends onto her property. She is asking what she should do. Tell her to get a survey first, make sure she is right about the property line, I said. Then tell her to document everything. Every conversation, every letter, every interaction. And should she let them finish construction or stop it immediately, I thought about that. Depends on what she wants. If she stops it immediately, she establishes clear boundaries but might not get any compensation beyond them leaving. If she lets them finish after warning them, she might be able to negotiate for payment or improvements. But she needs to be prepared for a fight. She is prepared. Your case kind of became legendary around here. Legendary. The HOA lawsuit where the homeowner actually won big. Do you know how rare that is? Most people either give up or settle for nothing. You held out and got a proper judgment. After we hung up, I looked up the statistics out of curiosity. She was right. Most HOA disputes end with the homeowner losing or accepting a minimal settlement. HOAs have lawyers on retainer, big budgets, and the ability to make your life miserable. Most people cannot afford the time, money, or stress to fight them. I had been lucky in some ways. I had a clear-cut case with excellent documentation. I had a good attorney who worked on a reasonable fee structure. I had the financial stability to weather the legal costs up front. And I had the personality type that did not mind conflict when I knew I was right. Not everyone has those advantages. That is why HOAs get away with overreach so often. They count on people not being able to fight back. That is why I donated to that legal aid fund. If my case could help establish precedent or give other people hope that fighting back was possible, then all the stress and frustration would mean something beyond my personal situation. The neighborhood settled into a new normal. The heated walkways remained a popular feature. The HOA operated more transparently. People seemed generally happier with how things were run. And I continued living my life, working from home, maintaining my property, and occasionally using those beautiful heated paths that I had never asked for but now permanently owned. On winter mornings, when fresh snow covered everything except those warm, clear walkways, I would take my coffee outside and walk the length of the heated section. Other neighbors would be out too, walking dogs or heading to their cars, everyone grateful for the ice-free path. They probably did not think much about the legal battle that had determined who actually owned that path. They just enjoyed the convenience. That was fine. The legal battles do not matter to most people until they are the ones fighting them, but I remembered. Every time I walked on that heated concrete, I remembered standing in the cold that February morning, watching the HOA tear up my land. I remembered the choice I made to let them continue. I remembered Patricia's face when she realized I was serious about the bill. I remembered the months of harassment, the legal proceedings, the neighborhood drama, and I remembered winning, not because I was smarter or better than anyone else, but because I was right, and I had the documentation to prove it, and I refused to back down when an organization with more power tried to steamroll me. That is what property rights mean. Not some abstract legal concept, but the real, practical ability to say this is mine and make it stick. To stand up to people who think their position gives them authority over your land, your home, your rights. The heated walkways would last for years, probably decades with proper maintenance. They would outlast the legal battle that had surrounded them. Future homeowners would use them without knowing the story behind them. That was fine too. The physical improvements remained, but so did the precedent, the lesson, the reminder that HOAs are not all powerful and that homeowners can win when they are in the right. I eventually sold that house, years later, when my job required relocating to California. The heated walkways were a major selling point, just as the realtors had said they would be. The new owner loved them and thought it was hilarious that the HOA had built them on my property at their own expense. "So I own these paths?" she asked during the closing. "You own the land under them," I confirmed. "The HOA has no legal claim to it. They maintain the system and pay the electrical costs under our settlement agreement. You just get to use them." "That is amazing. Make sure to keep the property survey somewhere safe," I advised, just in case any questions come up in the future. She promised she would. I like to think she kept that promise, that the survey is still in a file cabinet somewhere, ready to prove ownership if anyone ever questions it again. As I packed up my home office that last week before moving, I took one final look at the heated walkways from my window. They had been the center of one of the strangest, most stressful, and ultimately most satisfying experiences of my life. They had taught me about property law, about standing up for yourself, about the importance of documentation and the value of strategic patience. They had also taught me about HOAs, about how they operate, how they think, and how they respond when challenged. That knowledge served me well in California, where I made sure to buy a house specifically in a neighborhood without an HOA. No boards, no rules, no Patricia Morrison equivalents measuring my grass with a ruler. Just me, my property, and the freedom to do what I wanted within the bounds of regular city ordinances. It was refreshing, but I never forgot Aspen Ridge or those heated walkways. They remained a perfect example of what happens when institutional arrogance meets individual property rights backed by facts and determination. The institution lost, the individual won, and the community learned a valuable lesson about accountability. That is how it should work. That is how it should always work. The story of the HOA building heated walkways on my property spread beyond just the immediate neighborhood. Jennifer told me she heard it referenced in other cases. Other attorneys mentioned it when advising clients. It became a cautionary tale for HOAs and an inspirational story for homeowners dealing with similar overreach. I never sought that attention. I just wanted to protect my property and get fair compensation for what had been done without my permission. But if the story helped others stand up for their rights, that was a good thing. Years later, I still occasionally get emails from people who heard about the case. They share their own HOA horror stories and ask for advice. I always tell them the same things. Get everything in writing. Keep detailed records, know your property boundaries, and do not be afraid to stand up for yourself when you are right. Most importantly, I tell them to choose their battles carefully, but fight them thoroughly when they matter. Not every HOA dispute is worth a legal battle. But when it comes to fundamental property rights, when it comes to an organization massively overstepping its authority, sometimes fighting is the only option that preserves both your rights and your dignity. The heated walkways in Aspen Ridge still function, as far as I know. They are still melting snow every winter, still providing safe passage for residents, still standing as a monument to the importance of due diligence and the consequences of institutional arrogance. And somewhere, probably in Arizona, Patricia Morrison is probably still convinced she was right all along. That is how some people are. They never accept responsibility, never learn from mistakes, never understand that authority without accountability is just tyranny on a small scale. But she lost. The HOA lost, and I won, not through deception or trickery, but through facts, documentation, and the straightforward application of property law. They built on my land without permission. I let them finish, and then I held them accountable for what they had done. It really was that simple. The end result was fair. They paid for what they built on land they did not own. I got compensated for the use of my property. The heated walkways remained because removing them would have been wasteful and expensive. Everyone moved on. Well, almost everyone. I doubt Patricia ever moved on. But that was her choice, her burden to carry. As for me, I moved on completely. New city, new house, new projects. But I kept all the documentation from the Aspen Ridge case in a file box in my garage. Not because I needed it anymore, but as a reminder. A reminder that standing up for yourself works. That facts matter. That you do not have to accept it when someone with institutional authority tries to take what is yours. Those lessons are worth keeping. The heated walkways were just concrete and heating elements and electrical systems. But what they represented was much more significant. They represented the power of individual property rights, the importance of accountability, the value of strategic patience, the necessity of standing your ground when you are right. They were, in the end, the most expensive lesson the Aspen Ridge HOA ever learned. But it was a lesson they needed to learn. And it was a lesson that made the whole community better in the long run, even if the short-term cost was painful. That is worth something. Maybe even worth $168,000.